These 5 words are all you need to end any traffic stop in 2 minutes or less, and almost no American driver knows them. But before I give them to you, you need to understand what is happening right now on American highways in 2026, because the law changed and most drivers do not even know it exists yet. There is a brand new provision quietly rolled into federal highway safety legislation this year that officers across the country are already using. And right now, as you watch this video, the overwhelming majority of American drivers are in violation of it, including number 4 on this list, which is the one that will shock you the most. I have reviewed hundreds of body cam recordings and courtroom transcripts from stops made under this updated law, and what I am seeing is disturbing. Good people. Law-abiding people. People who thought they had nothing to worry about, losing their vehicles, facing federal citations, and walking away from routine highway stops with consequences that follow them for years. If you want to know exactly what this law says, exactly how it is being used against drivers right now, and exactly what to say to protect yourself the moment those lights come on behind you, hit that subscribe button right now, because I am releasing a full series of videos this month breaking down every right you have on the road, and you cannot afford to miss a single one. Here is the first thing you need to know. The new law includes what is called a Highway Compliance Interaction Clause, which formally codifies the first 60 seconds of a traffic stop as a structured compliance window. Officers are now trained to use that 60-second window to document driver behavior, verbal responses, and what they call cooperative indicators. Most drivers have no idea they are being evaluated the moment the car stops. They think the stop begins when the officer walks up. It does not. It begins the moment you pull over. So here is what smart drivers do. Before the officer even reaches your window, you have already placed both hands on the steering wheel in plain sight. You have already turned your interior light on if it is dark, and you have already made the decision not to answer any question that was not specifically asked. That last one is critical. The compliance window is not just about what you say. It is about what you volunteer. Every word you offer before you are asked a direct question is data that can be used to build a legal narrative around your stop. Under the 2026 framework, that data carries more weight than it did before. Do not give it away for free. Now here is the second thing you must know, and this is where most drivers get caught. The updated law created a new category of what officers can legally ask you during what is called the document processing phase, the time between when you hand over your license and registration and when they return it. In the past, your strongest protection in this window came entirely from Rodriguez v. United States, the 2015 Supreme Court ruling that said officers cannot extend the length of a stop beyond its original purpose without independent reasonable suspicion. That ruling still applies. But the 2026 Act introduced language that allows officers to ask a defined set of questions during document processing as part of what the law calls a highway safety assessment. These questions sound completely routine. Where are you headed today? How long have you been on the road? Is this your regular route? They are not routine. Each one of those questions is on a documented list of what the law now calls lawful assessment inquiries, and your answers can be logged and used to establish the reasonable suspicion threshold that Rodriguez requires. Here is what you say when those questions start. Officer, I am happy to cooperate. I would prefer to wait until you have finished processing my documents. That is it. Polite. Calm. Not a refusal. Not confrontational. You are simply redirecting the interaction back to its legal purpose, which is the documents. That one response is worth more than any explanation you could give. Number 3 on this list is the part that legal analysts flagged immediately when this law passed, and it is the part that officers are leaning on hardest right now. The 2026 Act expanded the definition of what constitutes observable reasonable suspicion during a highway stop. Under the old framework, an officer needed to point to specific articulable facts, a specific behavior, a specific observation, something concrete. Under the new language, the list of what qualifies as an articulable observable indicator was significantly broadened. It now includes things like route inconsistency, which means if you say you are going to a city that does not logically align with the highway you are on, that alone can be documented as a suspicion indicator. It includes travel pattern anomalies, driving at an unusual hour for the stated destination. It includes what the law calls sensory inconsistencies, which officers interpret as air fresheners, unusual odors, or the presence of items that do not match the stated purpose of travel. I want to be clear. None of these things on their own give an officer the right to search your vehicle without consent. Your Fourth Amendment protection still requires either a warrant, probable cause, or your voluntary consent. But what these expanded indicators do is give officers an easier paper trail to build reasonable suspicion, which then justifies extending the stop. Your protection against this is simple, consistent, and legal. You do not answer questions about your route, your destination, your travel history, or the contents of your vehicle. You do not explain yourself. You do not volunteer details. When asked those questions, you say, "Officer, I prefer not to answer questions about my travel." That sentence, on the record, closes the door on the indicator building process. And now we have reached number 4, the one that is catching the most drivers off guard, and the one that even people who know their rights are getting wrong. Under the 2026 law, there is a new provision around what happens when an officer issues a verbal warning rather than a written citation. In the past, once the ticket or warning was issued, the stop was legally over and the officer had no basis to continue detaining you. The new law introduced a post-issuance safety inquiry window, a defined 60-second period following the issuance of a verbal warning during which an officer can legally initiate what the statute calls a secondary safety inquiry. Most drivers hear the words verbal warning and relax. They think the stop is over. It is not. And in that moment of relaxation, they answer follow-up questions they were never legally required to answer, they agree to things they did not have to agree to, and they hand over the very justification the officer needs to take the stop further. Here is what you do the moment you receive a verbal warning. You say, "Officer, thank you. Am I free to go?" 5 words. Those 5 words are the ones I told you about at the beginning of this video. They are not aggressive. They are not a challenge. They are a factual legal question that puts the officer on notice that you understand the stop has reached its conclusion and that any continued detention requires new legal justification. Those 5 words have ended stops in under 2 minutes for drivers who knew to use them. Most drivers never say them. Now let me walk you through the full scenario so you can see exactly how this plays out in real life. You are on the interstate. You are an hour from home. An officer pulls behind you, and the lights come on. You pull over immediately and safely. Before he reaches your window, your hands are on the wheel and your interior light is on. The officer asks, "Do you know why I pulled you over today?" You say, "Officer, I am happy to cooperate. I do not believe I was doing anything wrong." No admission. Nothing to work with. He takes your documents and begins the highway safety assessment questions. You say, "Officer, I am happy to cooperate. I would prefer to wait until you have finished processing my documents." He processes the documents and issues you a verbal warning. The post-issuance window opens. He starts a follow-up question. You say, "Officer, thank you. Am I free to go?" He confirms you are free to go. The stop is over in under 2 minutes. Every right you have is completely intact. Now run that same scenario without those sentences. You answer the opening question. You answer the assessment questions. You get the verbal warning, and you smile and say thanks and wait. He asks one more thing. You answer. 30 minutes later, you are on the side of the highway watching your car get searched because you gave him everything he needed without realizing it. Same stop. Same officer. Completely different outcome. The only variable is whether you knew what to say. The constitutional foundation here has not changed. Your Fourth Amendment right against unreasonable searches, and your Fifth Amendment right not to self-incriminate exists specifically for moments like these. Rodriguez versus United States still protects you from unlawful stop extensions. Schneckloth versus Bustamante still means that consent to search must be voluntary, and that you have every legal right to withhold it. Terry versus Ohio still requires specific articulable facts before any search or seizure. What changed in 2026 is the procedural layer officers are using to build toward those thresholds. What did not change is your ability to stop them from getting there. Here is your full recap. In the first 60 seconds, hands on the wheel, light on, say nothing you were not asked. When the assessment questions start, officer, I would prefer to wait until you finish with my documents. If asked to consent to a search, officer, I do not consent to any searches. When the verbal warning comes, officer, thank you. Am I free to go? For responses. That is the entire framework you need for any highway stop in 2026. Smash that like button if this changed how you think about your next traffic stop. Drop a comment below and tell me which number on this list you had absolutely no idea about. And if you made it this far, you are already thinking about your rights differently than most American drivers. Do not stop here. Subscribe to this channel right now, because the next video I am dropping covers exactly what to do when an officer claims they smell something in your car. And that is the moment most people collapse under pressure and hand over rights they never had to give up. Every video on this channel is built around one goal: making sure you know your rights before you ever need them. Subscribe now. Stay informed. And stay protected out there.